Come on up to the stand, doctor.
Mr. Gobble and Mr.
Have a seat. You're still under oath. You understand that?
I do.
Okay. Any objection to going forward with that statement? Or do you want me to re-swear him? Okay. You got another document for us, I understand.
I do, Your Honor.
Okay. Now, if I remember correctly, you testified that he was the only doctor that used the fentanyl for these types of procedures.
He was the only doctor that had ordered doses in excess of 500 micrograms, not on a ventilator, over that 5-year period.
Okay. So you testify I wouldn't let the document in then. Okay? We're here today. Somebody asked you to do the document?
Yes,
Who was that?
the state.
The state did? And did they say why they wanted it?
I don't directly know.
Okay. Does it tell us anything more than you've already testified to?
Back to your original question, it doesn't rely on any peer-reviewed or privileged material any longer.
Okay.
But the outcome is the same.
Mr. Zion, anything of them?
Yes. The state asked you through a subpoena, correct?
That's correct.
So a subpoena issued under the authority of Judge Holbrook by way of the state, ducis tecum, for the previous material that was requested by the defense in 2020.
Correct.
All right. And the only difference between what we asked for after the judge excluded this report and what Ms. Menashe asked for in December of 2020, or excuse me, I don't know the month, but in 2020, was that in the body of the subpoena, it was stipulated ducis tecum that this could not, the compilation of such data could not use any confidential or privileged information, correct?
That's correct.
And were you able to, pursuant to that subpoena, use a process or system that resulted in a report, in a report?
Yes,
And
correct.
when was that report provided to the parties in this case, if you know?
It was toward the end of last week.
All right. And I'm just going to show you what I've marked for identification purposes as, well, before we get into this, how did you reach the conclusions in this report?
So the way the report is, we queried our systems to look for all doses in excess of 500 micrograms of fentanyl. And then you review the medical records of those identified to differentiate people who are on a ventilator primarily versus those who are not on a ventilator, because you cannot run a query that specifically calls that out.
All right. And who was involved in that process of examining the medical records and under whose direction?
It was under my direction, and it was myself and one other person, our chief medical officer.
All right. And the report that you produced on Friday, to your knowledge, is that fair and accurate reflection of what is requested in that subpoena?
It is.
So the actual records were reviewed by you and another person under your direction?
Correct.
What was the name of the other doctor that reviewed it with you? You said it was one of your chief medical.
Yeah, her name is Tammy Lundstrom.
Is she a doctor?
She is.
Munch. Go ahead. Spell it for her.
Lundstrom.
May I approach the witness, Your Honor?
You may.
So here's 34.
Jose is on.
So this is the original one produced
Mr. Baez, sorry.
to you guys. This is the one that was relabeled and produced a second time, which is just this with the label on it. And this is the one that was produced this week. So I'm going to show you what I marked for identification purposes as State's Exhibit 34A. 34B, and 34C. You said that there was a report that was initially under your direction, which did use confidential information as part of the compilation of that report, showing you what I marked for identification purposes as 34A.
Okay.
Does that appear to be that report?
It appears to be a report that was done using privileged material.
All right. And that was what was shown, or that was what was the subject of your original testimony. And for the record, Judge, 34A is what the court said, because it was used, compiled using privileged information, could not be admitted into evidence. At some point was 34A given a label which reflected what was contained in this report.
It was.
All right, showing you 34B, is that same report with now a title on the top?
It is.
Okay, and for the record, Judge, the title that was added after 34A was provided to both the parties 2 years ago, the title that was added last year was all instances in which patients within any Mount Carmel Health System received a dose of fentanyl at or above 500 micrograms while not in an operating room setting or on a ventilator. And then in parentheses, September 2013 to June of 2020. Is that what that label says?
That is what that label says.
And does that accurately reflect what this information is?
It does.
And just so we're very clear, in the entire Mount Carmel hospital system, that's the 4 hospitals, who's the only doctor doing that?
No, Dr. Husel.
All right. So these were excluded because you used the peer-reviewed material that was. All right. And was the subpoena that you received? Oh, you nodded.
Yes, that's correct.
And did the subpoena that you received, ducis tecum, after these were excluded a number of weeks ago, request this same information that's in this title of 34B, with the addition that it cannot be compiled using any privileged or confidential material?
That's correct.
Showing you what I marked for 34C, that's 34C. What is that?
That is the report that we created using the same guidelines, but starting from scratch, not using privileged material.
All right. And are there any other patient names on 34C that are different from 34A and 34B?
There are not.
All right. And are there any other doctors in the entire Mount Carmel healthcare system between 2013 and 2020 prescribing fentanyl 500 or above outside of the OR and while not on a ventilator?
There are not.
Thank you. And were the procedures you used based on your training and experience a reliable process that resulted in that said report?
They are.
Thank you. I have nothing else.
Mr. Baez? Yeah.
Dr. Ross, this is a list, right?
It is a list.
It's a list of names, and I'm referring to States Exhibit 34C, 34B, and 34A, correct?
Correct.
It's not a report, correct?
It is a report, in my definition of a report.
Okay, well, let's talk about your definition of a report. The query that Mr. Zion mentioned, typing into a computer and then generating a report of which someone who is given 500 micrograms of fentanyl outside of an OR and not on a ventilator, you cannot enter that and come up with this list of names, correct?
No, the report requires both an automated query of the system as well as medical record review.
Okay, so in other words, this, based on what was the questions asked of you, is not the direct result of a query into a computer, correct?
No, it requires a further medical record review to generate the report. That's right.
And
I'm sorry. It requires a further review of the medical records to generate a report.
so, in light of that, you had to take names off when originally entering something into a computer, correct?
The final report removes names that were for people that were on a ventilator. That's correct.
Okay. And the person who did, and the way you do that is by reviewing medical records.
That's correct.
And you are a hospital administrator,
Sure, yes.
but you just happen to also have a background in medicine, correct?
I'm a physician, yes.
So in light of that, when you said that your process was reliable, kind of giving yourself some props there, right?
Yeah, I'm a physician. I'm comfortable with medical records.
You're saying I didn't make any mistakes because, well, you're not saying I didn't make any mistakes, right?
If I knew of mistakes, they wouldn't be in the report.
Well, you would know you made a mistake, correct?
That's correct.
Okay, so no one went and checked your work, right?
No.
And no one went and checked Miss, what was her name?
Dr. Lundstrom.
Dr. Lundstrom. No one checked Dr. Lundstrom's work.
We check each other's work outside of the two of us. That's correct.
You went through all the records she went through,
Yes. Well,
even the ones that you took off.
no, we talked about them together.
Okay, and
Help me out, Doc, let him finish his question,
I'm sorry.
okay?
Yes, Your Honor.
what's the name of the software that was used to generate the first list of names?
The name of the software.
Yes.
So we have an enterprise data warehouse that extracts the data from an electronic health record called Cerner.
Cerner. So, do you know when the last time the Cerner system was updated?
I do not off the top of my head.
Okay, do you know how often it's updated?
Regularly, but I do not know.
And you can also testify as to the entries given on the Cerner system, correct?
Can you clarify?
You can't testify to the reliability of the entries put into the Cerner system, correct?
By the physicians, you mean?
Or nurses,
Or nurses? No, we rely on the medical records as they are.
okay? And these patients' names that came out in the first list, did you print those out?
Yeah, did we print them out? No, I never printed them out.
Okay, so you never printed them out and turned them over to the state of Ohio?
Correct.
And you never, of course, turned them over to anyone else, right?
No, correct.
And you never hired an independent company to go ahead and review these medical records to verify your work?
Correct.
Or the work of Miss Lundstrom, was it?
Correct.
And in addition to that, you specifically excluded people outside of the OR, correct? Patients outside of the OR.
We excluded patients in the operating room. Is that what you meant?
No, my question is, based on Mr. Zion's question, you excluded patients outside of the OR, correct?
That were on the ventilator?
Well, that's my question to you is, did you exclude people outside of the OR?
Yes.
Okay. And in fact, you can be in the OR and not be on a ventilator, correct?
Correct.
So if a patient is given 500 or more micrograms of fentanyl and they're not on a ventilator in the OR, that would be ones that you didn't review.
Correct. They're outside of the request as we received it over the last few years. That's right.
Okay. So that's not part of the request. And therefore, you could never say, based on that query alone, that there weren't other doctors giving 500 micrograms of fentanyl for someone who was not on a ventilator, correct?
But was in the OR?
Correct.
In the operating room? Yeah, that would be correct with that change.
And how many names came up initially in terms of the 500 micrograms of fentanyl?
How many individual patients?
Yes.
67.
Okay. And again, you said that you didn't print these out.
Correct.
So as you reviewed the medical records, there's more than one page on the screen, correct?
The medical records themselves?
Yes.
Yeah, no, there's many, many pages in the medical
There
records.
many screens.
Correct.
at a time. I can have testimony, Judge. I have no further questions, Judge.
So you didn't learn anything new?
The same names show up, that's correct.
Okay. Anything else?
No.
Okay, you can step down. Any more comment?
Your Honor, it's obviously relevant that Dr. Husel is the only one in the entire Mount Carmel Health System prescribing 500 micrograms above outside of the OR and off the ventilator. It was compiled in a reliable fashion. We have the witness here who is subject to cross-examination, should they wish to inquire about that in front of a jury. And the reason that we asked for the second report was because you excluded the first report, which, known to all the parties, right there on the form when it was given in March of 2020, that this was produced, it's confidential, subject to protective order, produced to the defense as well and at the defense's request, so you excluded that. So we just said, well, let's fix it. So that's why, and it is the same exact information. So it's not like they can say, oh, now we got all brand new information. They've had the same information for 2 years. There was a question of admissibility because of the way it was compiled. We fixed that. We would ask that Dr. Roth now be allowed to testify to the report and to that fact. So that's why we went through the trouble of subpoenaing the same thing they subpoenaed with the caveat, the problem you had, and that was your ruling that, hey, you can't use it because of the confidential material that was used to compile it. They've now fixed it. We should be allowed to use it. Thank you.
Mr. Raz?
Again, this never addresses the main issue here, and that is that the court ruled pre-trial, court ruled in the middle of trial, both of which is that we couldn't have access, is that this was based on privileged information. Now, the fact that they went back and attempted to fix something still doesn't relieve the prejudice to the defense that we were not on notice that we would be trying a case having to deal with this type of evidence. In addition to that, there's no reliability factor. We can't go ahead and cross-examine the second doctor, and in addition to that, we don't have these records to verify or to challenge the accuracy of the work done by Dr. Roth and by Dr. Lundstrom. If this were going to be an issue at trial, we could have asked dozens of witnesses, or numerous witnesses, I should say, about this document and bring it and actually discuss its reliability. This also brings up Dr. Roth as a new expert, because now he is actually reviewing records and making determinations, which actually we were not placed on notice that Dr. Roth would be called to testify as an expert witness in this case. He essentially is, and now he's generating reports, which is really a list of names. In addition to that, even their own final document says, confidential, subject to protective order, produced pursuant to terms in March 16, 2020. So, I don't know what to make of that either. So it's just one thing on top of another, on top of another, on top of another, which still doesn't get past the issue of we were not placed on notice that this was an issue that I could address at opening statements, in cross-examining other potential doctors at Mount Carmel, other potential administrators at Mount Carmel, and they just decide to, again, ignore the orders, the previous orders issued by the court, and start generating evidence towards the end of trial. I can't even say it's the middle of the trial. towards the end of their case in chief and were significantly prejudiced by this and have no way to effectively cross-examine this doctor based on whatever he did. He could have literally gone back, turned on a computer screen, had some coffee, had a sandwich, called it a day and said, oh, yep, I reviewed this. I have no way of knowing that, and I have no records to be able to cross-examine him with. We've been doing this throughout this trial with witness after witness after witness by bringing up records to show certain things that are inaccurate based on their testimony. I can't do that with this witness or Dr. Lundstrom, and I couldn't have done it with other witnesses to discount the credibility of this particular witness, which essentially means we do not have the right to confront Dr. Roth in the admission of this evidence. What we do have then is we have this already issue lingering out there that we still have to address, and that's not enough for the state. They want to double down and ask this court to now throw in evidence that was developed later on and not disclosed to the defense. And I just don't understand how we are at this point and how we resolve this issue, other than, one, not admitting this, and two, of course, figuring out a way of dealing with not only the Dr. Roth issue, but this other phantom report that Dr. Swanner testified to as well.
Any response back?
I don't know how else to say the words that I've said over and over again. This isn't new. This is 2 years old. This was produced at their request. The same material was reviewed. The same processes were used, except in the new report, the court found it that they couldn't use the confidential material, so we just said, do it by hand, or how he described, without using the stuff that you previously ruled. It's the same things that they've had for 2 years. This is not new. And we talked about it, has attached to our email. I mean, it's not only not new, like last summer, they provided to us a title to this. So it's not like it's new then. We said, hey guys, this report, Mount Carmel's now added a thing on to say this is what this is. And then we emailed the defense and said, we want to use this. Let's talk about this document and how it's admissible. And we thought we had an agreement as to its admissibility, as long as Dr. Roth testified, which we said, fine, we'll bring Dr. Roth in to testify. And we have those emails that are attached to the record that were all done pre-trial. After the defense got it, after it was relabeled a year ago, and we had those email discussions ahead of time. This is not something brand new. This was to fix what the court said was a problem with its admissibility a couple of weeks ago, and it's the same information. It should absolutely come in, Judge. This is not a discovery violation. This is not nothing new. This is just us addressing an issue the court had an issue with. So that's all I can say. Thank you. I don't know how else to say those words. Thank you.
I would just add one last point, Judge, if I may. Just because something is not new doesn't make it admissible. If the state wanted to use this evidence and was so dead set when the court denied the admissibility of it pre-trial, they could have requested a continuance to have this report done a certain way. Again, we keep calling it a report. This list done a certain way, and then disclosed it based on the non-privileged information. Then we would know we had to deal with it. Then we would know in that opening statements we had to deal with it. Then we would know with cross-examining witnesses that we had to deal with it, and so on and so forth. You can't just throw things out there and say, well, you knew all along. That's not the case. That's not the standard. Admissibility is the standard. It was found inadmissible pre-trial. They did nothing to try and cure it pre-trial. And we go through the entire trial. Oops, we made a mistake referencing privileged information, which, again, then you still have that issue whether it was a mistake or not. And then let's just triple down on it and bring it up again later and try and see if we can get a third bite of the apple. So again, the fact that it's not new has nothing to do with this. They had an opportunity to cure it, they never did, and they're waiting till the end of their case to try and cure it and get 3 bites of the apple. So for that reason, we said on that in our prior arguments.
Pre-trial ruled that certain documents were privileged, therefore not discoverable by anybody. We kept that in there. That's the order that's been the basis of the problem here today. So I did not have that specific report at that time, but I said all the underlying stuff done for the medical mal was not discoverable. Okay? That's issue one. At trial, it ran into the problems where they used documents they weren't allowed to use. We all went through those arguments, and you all followed my rule. We're here today. My problem is as follows. He testified about the very nature of that report during his testimony. To recall him with a cumulative document, I don't think he can do it at this time. Now, it doesn't mean he won't be subject to it on rebuttal, but for now, it's cumulative. It's a summary of what he already testified to. What's the value of it? And the points about this being generated recently, we don't have any way to audit it, those things. Reliability is an issue in the background they really can't cross on. So for this time, no, the report doesn't come in. So ruled. Okay? Anything else for the record, Mr. Zion?
What evidence rule are you citing when you say cumulative document, Judge? I just want to, so I understand.
403.
403.
Okay, a document comes and goes. He's already testified about these facts. He creates something after he testifies that basically verifies what he testified to. Isn't that not by itself a cumulative fact when they really can't cross on it because it occurred afterwards? They don't have any other information than here. I tried to make them available. Essentially, the prejudicial effect of the cumulative evidence outweighs the beneficial use. 403. Okay? Anything else?
Yes, Your Honor.
Yes.
One thing, and I bring it up only now because of the next witness. Oh, wait, just, Your Honor, cumulative, but with respect to testimony, I just want to raise that it's my understanding that the next witness that the state intends to call is an individual, Tara Schwartz. It is a second family member with respect to Bonnie Austin. As we all just heard, we heard from Ms. Austin's husband just now. The state has, as a matter of practice, called one family member or representative for each patient. I believe that Ms. Schwartz's testimony would be cumulative in nature, particularly given, Your Honor, that Mr. Austin just testified that he was the one that made the code change status. He didn't say those words, but he said, pull the plug, and then he walked away. I anticipate what the state's argument will be, Your Honor, that there is no limit, but I would just make this argument. It is the one patient that they are having two family members to. I have reviewed Ms. Schwartz's deposition. She did not give a Columbus Police Department interview, and I would just note the cumulative objection in advance of her being called.
Okay, well, the problem becomes there is the witness that just testified, he had his memory was directed towards what occurred there at the end. All the other questions you asked him, any other statements, he didn't remember. So if they've got adding additional stuff, I don't mind the witness being called. Okay, if they're going to say other statements said by other doctors or other things like that, I think it's perfectly relevant. Because he could only fill in the one thing, and I believe his testimony was after he talked to Dr. Husel, he took a long walk. So there may be facts that occurred then that could be brought up by this person. So I understand your objection. There is no definitive number on the number of witnesses to an issue, just as long as they're not cumulative. So, okay, anything else?
Judge, we want to make sure the record is clear. There was no pre-trial order excluding that report. I think you said that.
I did say that.
Okay, just want to make sure that's clear. I've got appeals back here.
It was excluded because it included part of that peer review group.
So when they are accusing us of our third bite at the apple, we never addressed this report in any pre-trial motions. And then, second, we would like to proffer these reports for the record. We'll mark them as state's court's exhibits, so the record does contain them. And then we would also, just so we're clear, then the testimony about what is contained in this report stands. It's not being stricken at this time.
Not being stricken.
Thank you, Your Honor.
Okay, just for the record, it'll be, I think we're at 14 for court exhibit. Since we dealt with it directly, it'll be all three reports. Why don't you people copy them during the lunch hour? We'll label them as court's exhibit 14 for the record. and that way you don't lose your exhibits.
Thank you, Your Honor.
Okay? Anything else?
That's it.
Okay. Enjoy your lunch.